I'm a licensed attorney in the state of Illinois, and I'm the director with the Dolan Consulting Group here in Raleigh, North Carolina, where I'm recording this webinar for the Manhattan employees throughout the city that will be attending this sexual harassment liability webinar. I would imagine in piecemeal fashion as you get an opportunity to sit down and take a look at this recording. This is a webinar that was put together with you as the audience in mind, looking at your circuit specific and your state specific, and in this instance, looking at your actual policies, that you have policies and procedures in Manhattan, and how that plays into sexual harassment liability. Oftentimes, I'm speaking to a group where I've got people from 5, 10, 30 different agencies, cities and counties, but in this instance, I wanted to focus it to your audience, hopefully something that's more applicable to you. And by doing it in this recorded fashion, giving you an opportunity to sort of take a look at it when you get the chance. Obviously, it's not something that everyone can convene in one location. So with that, I want to give you just a touch more background on myself and then jump into the topic of this recorded webinar. So as I mentioned, I'm a licensed attorney in the state of Illinois. I attended Loyola University Chicago School of Law. After that, I was an attorney, a plaintiff's attorney actually, for about 3.5 years in Chicago. In that capacity, I never was involved in lawsuits involving cities, townships, in particular law enforcement agencies. I come from a cop family, and I was very concerned about that, really reflecting poorly on me and maybe being an awkward dinner conversation at Thanksgiving. So I was focused on the private sector. And as a side note, if you'll allow me, here at Dolan Consulting Group, most of what we do, not exclusively, but most of what we do is public safety agency training, although we are increasingly hearing from folks like the attorneys and HR folks that represent Manhattan, letting us know that a lot of the challenges that we talk about in public safety, hey, that's not just something that we want our people in the police department or in the fire department to be aware of. We want everybody to be on the same page, because the law is really consistent. The standards are consistent. The examples may change. We're talking about parks and recreation versus a police department, but the fundamentals really don't in so many cases. So when I was practicing as a plaintiff's attorney, it really kind of gave me an interesting perspective, I think, now that I've spent 7.5 years or so working full-time as an attorney that trains municipalities, counties, towns, states in liability identification and prevention to the extent possible. There's always going to be liability issues, but we try to manage them as best we can and to try to get in front of them. And to the extent possible, try to talk about them before it's an issue that is really causing a lot of internal strife, is causing a lot of negative publicity locally, and some maybe loss of public trust and some controversy. Life's too short. We've got enough on our plate without having these external distractions that often come from not taking preventative action on the front end. So did that for a few years, and then as I touched on, for 7.5 years now, I've been focused not as an attorney that does this on the side, but someone who is focused on training for government entities full-time and trying to focus on the personnel side of those things. So with that said, this topic is something that is very relevant right now. It's something that obviously in the national news media, this has been a topic of conversation, and that's sort of filtered down, I think, to some extent to a lot of localities. Prior to 3 months ago, 4 months ago, whenever it was that so many of these stories involving Hollywood and media started to come out, I certainly was already involved in sexual harassment liability training, knew that it was an issue that many departments, many agencies, cities and counties face across the country. One of the big things I really want to start off with, especially when we're talking about that public trust term, the idea that we've got public employees, we've got people that are taxpayer funded, that are representing the citizens of a community, particularly in those cases. I think it's important to identify the difference between what is the legal standard versus what is the agency standard, what is the city standard. And in other words, just because it's something that, strictly speaking, you could have a defense attorney, and I hear things like this all the time. A defense attorney takes a look at something and says, I don't think this is bad enough. Just to speak plainly to you, I don't think this is bad enough. I think what happened was not okay. I think it's not great. I think it's slimy. It's uncomfortable. It's inappropriate. But is it bad enough under the 10th Circuit case law that I'm seeing to rise to the level of hostile work environment? Not quite. But at the risk of sounding cheesy to you, I do mean what I'm about to say to you, which is I would hope we would hold ourselves to a higher standard. I would hope that when we talk about whether it's a police department, a fire department, parks and recreation, streets and sanitation, people that are representing the city, I would hope that we would hold ourselves to a higher standard, and I would say that of any business. I would say that of Dolan Consulting Group. We're a small business. We only have, what are we up to, 7, 8 employees, but we would hopefully have an environment where even if it wasn't something that, strictly speaking, triggered liability, I would personally hope that we would hold ourselves to a higher standard than that, and that we would address things even if they don't necessarily trigger that type of liability immediately. The other part of it is if we have problems that fly in the face of common sense, if we have problems that common sense dictates this is inappropriate, this is a problem, this isn't okay, do we address it now, or do we say, well, yeah, it may violate our policy, but it's not really anything that anyone's going to sue about anytime soon, and let's kick that can down the road. I'm not a big proponent of that because I would venture to guess that for most agencies, there's not a very good track record there. And that what's really disturbing, and you could take this back to what makes it worse if it's a national scandal, something that grabs the attention of all the news outlets, or if it's a local controversy. What always makes it worse is people do. That's always what makes it worse. What always makes it worse is, well, this person had a nickname, or it was known, or this activity had a nickname. And I'm going to touch on that a bit more in the 2-hour webinar. But those are the things that really trigger liability later on. But as well as liability, and I know that it's right there in the title and it's right in front of you, but on top of liability, what it does is it really triggers a lot of resentment from folks in the community, and it makes things look a lot worse when the idea is it's bad enough that this happened, but wait, this was going on and you knew about it in some way. It's brought to your attention, but you didn't think it was bad enough. That always makes it worse, and to be honest with you, I can't help but see so many news stories where that's really the question, is who knew what, right? And so rather than going the plausible deniability route, which I think has its own ethical problems, as well as being something that typically is futile from a liability standpoint, let's not go there. Instead, let's try to get our arms around this problem, address it head on, and see what we can do to try to manage it. Now, with that said, I've been brought into rooms and brought into agencies, and sat in and done in-class trainings, and the problem comes up of, well, what is sexual harassment? How do you define it? I'll be very honest with you. When I look at a group of grown men and women, when I look at a group of adults, I really don't think it's necessary for me to go down a laundry list of what's okay and what's not okay, especially if we're holding ourselves to a common sense standard of what's appropriate, that's not okay in the workplace. I really don't think that it's anything where I need to go through and say, this is okay, this is not okay, this is an okay thing to do with your hands, this is an okay thing to leave on someone's desk, this is an okay thing to put on somebody's computer, to put in their locker, whatever the case may be. I think, generally speaking, we have some common sense about that. A couple of common sense tests I would utilize, if you'll allow me. One I referenced just a minute ago. Does it have a name? Is this something where we all know that this is problematic and it's known? It's a name. It's got a nickname. The activity. Another thing I would say, frankly, is if this was somebody who you say to me, you argue, well, and this is something I hear all across the country. Well, they were smiling. They laughed. Okay, got it. So they laughed. First of all, if that's your best defense, I'm getting very nervous. If your best defense is not, well, that's not inappropriate for us to do in a workplace, my defense is, well, if they're laughing, then who's to say? That to me is a red flag if that's your defense. But let's put that aside for a second. What if that was a loved one? What if that was a spouse? What if that was an adult child? And they told you this is what happened at work today. Would you care if they smiled or not? Would you say, oh, well, that's fine? Or if they told you it bothered them, would you say, buddy, sweetie, whatever, you gotta lighten up? That they just sound like a fun bunch. They're just having a good time. Ask yourself that question in a serious way. Is this something where, if it was a situation where your spouse, your significant other, whatever, was bothered by it, would that be something that you would just say, well, that's ridiculous, you need to just get thicker skin? Because I would venture to say that in many cases, we have things that become tolerated inside of a work environment. And if we're honest with ourselves, if we're really honest with ourselves, we wouldn't say that to our spouse. My wife wouldn't say that to me. I wouldn't say that to her. It would be outrage. It would be anger. It would be something needs to be done, regardless of whether or not the person in question smiled or laughed. And I know that that's a broad, sweeping thing to say, But I think that that's a common sense approach to it, because again, we can get so in the weeds about, this type of activity, that type of activity. Whereas in so many cases, I really think that, and I know that there's all types of different folks from different departments within the city that are going to view this, but I really think that if people weren't going in with an agenda to try to make a point, if we really had people on truth serum, if they were being honest, all right, raise your hand when you see something that's inappropriate in this video, or when I'm telling you this narrative, raise your hand when you think, hit the buzzer, this is a problem. I don't think we would have a big debate. I don't think we would have 50-50 down the middle. I don't even think it would be close. I think we would have 90, 95%, close to 100% of people saying, yeah, that's not okay. Especially if you don't say, well, it's this person, that person. If you just let them know, should somebody have to come to work, and that's what they walk into on a daily basis. Speaking of a daily basis, so there's two things we really look at when we talk about sexual harassment in the workplace, and the first one really applies to any supervisors that are viewing this webinar as much as anybody else, and that's an employee is required to choose between submitting to sexual advances or losing a tangible job benefit, and that's our quid pro quo version of sexual harassment in the workplace, and that's one that typically we don't see in the cases that I review, the narrative that I see in 2018. I don't think they look as blatant as they did maybe in 1980. You don't see as much of this needs to happen, or else you're not going to get a raise. This needs to happen, or you're not going to get a promotion from a supervisor. It's not so much that. More, it's you've got a supervisor who spends the first 5 minutes of a conversation talking about how good somebody looks and what they'd like to do, and da-da-da-da-da. And then the second part of the conversation, hey, completely unrelated, but I'm going to be one of the three people sitting on the panel to decide the promotions, and I think you've got a lot of potential. But anyway, enough about work. Did you want to come by tonight? See, when you have those two conversations and when they're being melded together that way, what do a lot of cases tell us? And what do common sense tell us? Well, what does that mean? Is that code? You see, all of a sudden, when you're a supervisor, and I would say this of everybody, I would say, and you're going to hear me say this a couple of times, I think you should be different at work than you are at home, because I know that whenever I speak about this topic, I know that I can sound very stiff, maybe, if I'm not careful. I can sound very robotic about what's appropriate, what's not appropriate. Listen, I don't think you would be a human being if you didn't say things, sitting on your couch, chatting with your best friend, your significant other, if you didn't say things, you didn't have in a relaxed setting, social setting at home, if you didn't say something, and I don't mean horrific stuff, I don't mean, horrible, god-awful things, but say things that, would you want your subordinates to hear that? Would you say that at work? I would hope that the answer is, we all have those. You follow me? And I would put myself in that category. To say, look, if you're at home and you're having a drink on a weekend and you're chatting with your spouse, you're chatting with a couple of friends, and you say something and it's not work-related, you make a joke, say something, and you wouldn't want it in the paper. You wouldn't want it to be something that's being reviewed by your city attorney, by your HR manager. I think that makes you a human being, and in many cases, probably a well-functioning human being. Well, good. I mean, there's a difference. But when you put on your work attire, and when you go in, especially when you've got a supervisory status, are you putting your game face on? So to put it in a cheesy way, as I tend to, are you putting your game face on? Are you recognizing that there's things now that I could say last night, I could say on Saturday at the barbecue, and it would be lighthearted and it would be taken in the spirit in which it's intended. But here I'm at work. This is not the same thing. This is not the same thing, and I think that many times blurring those lines is a dangerous thing from a liability standpoint, from a well-functioning workplace standpoint. Again, I don't want to come across as suggesting that people can't say things. I have this conversation a lot, if you'll allow me, in the social media context. There are things that have gotten, especially dispatchers, police officers, have gotten them fired because they put it up on Facebook. And then the pushback I get is, well, can't you vent? Can't you vent about Colin Kaepernick, or can't you vent about the neighborhood that you're working in, the lack of support that you're seeing on this beat? Can't you vent about that? And my response is absolutely. With your computer closed and with your cell phone down, right? I'm not naive enough to assume that we can expect people 24 hours a day, 7 days a week to have their game face on and to be professional, to never lose their temper, to never vent. And so I find myself, again, as someone who trains law enforcement, look, you come home from a rough shift. You see something on TV that annoys you, that you take as being anti-cop and unfair. Okay, got it, whatever that is. for you to come in the front door, throw your jacket down, and say to that person in your life, okay, can you give me 10 minutes? I got to get this off my chest. Oh my goodness, right? Crack open a beer and just unload for 10 minutes. And then take a deep breath. All right, let's put something on Netflix. I'm not on a mission to stop that, right? I think that would be a ridiculous thing. The difference is don't broadcast it to the world on Facebook. Similarly, don't broadcast it to the world at work, right? There's things that you just want to make sure that you have a distinction there. There's a line there, and if there's not, I think that's something that's a common sense test. With that being said, getting us back to quid pro quo, you got to be careful. This is not eHarmony. This is not a speed dating service. Now, I say that with a cautionary note in my mind of, well, I've got my godfather, who I've got a police family, father, uncles, grandfather, his brother's great-grandfather, my godfather, who's not a blood relative, all these cops. He met his wife of 25 years on the job. So I don't want to say, well, we've got to make sure that nobody ever meets, nobody ever dates at work. But there's a distinction between saying, well, we met at work versus, while we're here, we got some time to kill. I'm just going to take, no, I'm not interested, or no, I'm still married, as a negotiation counter. And then I'm going to come back tomorrow with my new pitch, right? And I'm not at all trying to say that hey, you should make advances on your favorite subordinate, but do it only once and do it the right way. That's not what I'm trying to say. What I'm trying to say is really what gets so many supervisors in trouble is not just the quid pro quo, but when you look at hostile work environment, it's unwelcome sexual conduct that unreasonably interferes with an individual's job performance. So much of that comes down to the frequency with which we see it. So there's many cases that come before even courts. So I've already said we're holding ourselves to a higher standard, and I certainly understand from looking at the policies and procedures that the city of Manhattan wants to hold its employees to a higher standard. But even if we just look at the legal standard, you've got some cases, many cases, where the quote, what was actually said, isn't shocking to most people. The straw that broke the camel's back, if you will, was somebody letting it be known without using vulgarity, without using profanity, anything like that, just simply saying, hey, listen, what are you doing later? It's a snowstorm, but I know one place it's still open. You want to go get a bite to eat. You want to get a drink. And then that ends up being this big hostile work environment lawsuit. And you say, really? That's hostile work environment? Here's the rest of the story. See, this is the 50th time this has happened. You follow me? This is something that is a daily occurrence, and then something that is in and of itself not actionable. And I would even venture to say something in and of itself that most HR folks, most city attorneys would say, okay, can we tell Dolan to knock it off? This doesn't need to be the trial of the century. This doesn't need to be a big internal investigation. We just need to tell him to knock it off. But when the frequency is such that we see this happening on a regular basis, that's really when it becomes problematic. I know I've touched on this before, but I want to make sure that it's part of your slides. Clear distinction between harassing behavior that we do not tolerate as an agency and behavior that is deemed actionable by the federal courts. Again, we have to make sure that we look to that. The standard is not we didn't violate the law. This is not something actionable. We've got an attorney that says this is not something that this person can sue for. Aren't we holding ourselves to a higher standard than that, right? That's something that I think is really important. So if you have a policy, you want to look to that. And also, let's be very clear. Generally speaking, management, the city, they have a right to hold you to a higher standard. There's a lot of things that are not unlawful that are fireable, to take it to an extreme, right? It's not unlawful. Didn't violate a law. It's not something you could be thrown in jail for, but that doesn't mean you can't be fired for it. Now, similarly, there's some things that, yeah, the 10th Circuit may say that, yeah, you may be right. Yeah, maybe the 10th Circuit would say that that's not hostile work environment, but it's still unacceptable, still inappropriate, still not how we do business here. Management has a right to draw that distinct line. So, yeah, is it interesting to talk to attorneys or to Google it or to try to, get a sense from your attorney that's speaking to you, your city attorney? Well, did I violate the law, strictly speaking? Is this something that's legally actionable? Is this $1 million lawsuit? That's all interesting. But really, what's the responsibility of all the employees of the city to follow the policy? Especially when the policy is not a secret, when the policy has been in place, it's been communicated, and when we talk about it being communicated, I think that when you're having a webinar like this is one of many opportunities, I'm sure it's not the first, many opportunities to talk about that You look at the sexual harassment policy here in Manhattan. The city's purpose is to create a workplace environment free from harassment, sexual harassment, and related conduct or forms of discrimination. So that's a pretty broad, sweeping statement. You know what I don't see in there? The city's purpose is to create a workplace environment free from that which would get us sued successfully, free from that which would result in sizable settlements or jury awards. Hopefully you're following me. This is the challenge with webinars. I can't see if people are nodding or they're nodding off. But what I'm really trying to get at here is, are we really saying here that we're going to try to create an environment that's all about liability? Now, again, I find myself saying many times, as someone who's trying to minimize liability, a lot of the things, not all, but a lot of the things that get us sued are things that, I'm sorry, folks, we shouldn't be doing anyway. And that's not just about sexual harassment. If we really are honest with ourselves as organizations, if we're honest with ourselves as a city, doesn't mean that we're lousy, doesn't mean that this particular department, everybody's a bunch of bums. But if we're really honest with ourselves, in most cases that I see, do I think that there's some fault? Well, yeah. Well, there's this, that, the other, what the attorney said, what they brought in, the media coverage wasn't fair. Okay, maybe there's some truth to that. But at the end of the day, are we completely clean here? Do we have clean hands? I think in most cases the answer is no. So we really want to look at, well, why, if I can be in a position to speak for the city, I think it's a common sense reading between the lines on this. But I think we've got the city of Manhattan saying we want to actually hold people to a standard where we've got men and women that come to work, and they should be able to come to work without having to deal with nonsense, right? They should be able to come to work, and we can't promise them they're never going to have a bad day. We can't promise them they're always going to like their job assignments, or that they're always going to be best friends and get along swimmingly and be someone that gets along great with all of their supervisors, their coworkers, and their subordinates. We can't guarantee that. But what we really want to make sure we do guarantee is that you don't have to come into work and be harassed, sexually harassed, discriminated against. And that's just the way that we do business. Is a correlation there? Is there a correlation between that and liability? Well, sure, but let's keep our eyes fixed on what the standard is. The standard is not just the liability stuff. The standard is, what does the city of Manhattan expect of its employees, right? And then a lot of this conversation we're going to have in this time today is talking about where does that come from and what are the reasons behind it, big picture on it. But let's not lose sight of the forest for the trees. We've got to take a look at what does the policy say and why does it say that. It doesn't reach the level of actionable harassment under the law, but is it still evidence of gender discrimination? See, there's countless cases that I don't have time to get into where, no, what was said, inappropriate, right? Inappropriate, harassing, vulgar, unnecessary, has nothing to do with the job, not okay. Something that you should be saving for your personal life if you want to say things like that. We're not coming to your house snooping around to see if you say something inappropriate, but at work, it has no place. But it's not bad enough. Not bad enough to be a hostile work environment. Not bad enough to be quid pro quo, sexual harassment. But then in a year or two, if somebody is denied a promotion, if somebody is fired and they say, well, I'm being fired, but so-and-so over here did something just like this and he didn't get fired. Or so-and-so did something like this and didn't get as many days off without pay. There are countless cases that come out where these types of statements are used as evidence, not of sexual harassment, but of gender discrimination. Right? That if this is being accepted, if I'm having to put up with this on a regular basis at work, maybe it's not quite bad enough to be sexual harassment, but is it harassing behavior under a common sense definition? Is it something that's relevant as evidence of discrimination? Well, certainly. Same thing goes for pregnancy discrimination. When there's comments that are made about women being pregnant, about are they going to get pregnant, or different jokes and things that are made. Okay, maybe it's not bad enough to go beyond the city of Manhattan standard. Maybe it doesn't get to the 10th Circuit standard of actionable sexual harassment, but is that going to be brought up if it just so happens that somebody is disciplined or in some other way denied a promotion when they're pregnant? You have to think this way, because so much of this stuff, it's not that big of a deal. But what your attorneys are telling you that work for the city, what your HR folks are telling you is, see, we're seeing around the corner. And to some extent, I'm not familiar with Manhattan's last 5-10 years and the different cases that they've dealt with. But if they're like almost every other good-sized city in the country, they've dealt with some issues. And even beyond that, you've got HR folks and attorneys who I'm sure are bright enough to look to comparative cities and counties, and they pay attention to what's going on in the world, and they realize that could be us. So what they're saying is, we see around the corner. And number one, that I'm going to keep hitting is this isn't how we do business. We don't expect people to have to tolerate it. This isn't the type of workplace that we want. It's not what we would want for our spouses, our adult children, our siblings, you name it. And on top of it, it's something where we see around the corner where now, it's not quite bad enough, but you know what? It's bad enough that people are going to remember. It's bad enough that it could be involved in a deposition. If we have to discipline or terminate someone for cause, for a very good reason, we had an obligation to the community, to the taxpayers, because they were getting in the way of what this department's mission is. Maybe it was a safety issue, you name it. But now we're looking at a lawsuit. And what's the gasoline that's going to fuel their lawsuit? It's something that was said 6 months ago. It's something that was done a year ago. So often I think that gets missed. What's the big deal? Well, the big deal may not be a lawsuit today. It may be in a few months, maybe in a year. Here's another problem. Maybe it's something where today, every indication is the victim, if you will, the person who's the target, I guess, of the inappropriate behavior, doesn't see a problem. What if that person sees a problem in 3 months? When do we flip that switch and say all of a sudden the thing that's been tolerated for the last 9 months, now we're going to get on top of it, right? And we can't deny that knowledge. And at a certain point, when is it something where some things are just common sense, objectively unreasonable? And even if the person who's the target of it says, no, I think it's great, well, we don't. And I don't want to go too deep into this, but are there some common sense things that we can say, I don't care if those 2 people or those 3 people or those 4 people, I don't care if they think it's okay. That's not okay. I'm sitting here working, I'm not the target of it. I'm just trying to have a cup of coffee. And I'm looking at this saying, good God Almighty, this is not something that should happen working for the city of Manhattan. I mean, I think use your imagination, folks. We've got people that can put together what I'm trying to communicate in different ways. There's some things you could see, you go, oh my goodness, geez, I can't believe they're doing that. But they all say that saying those kind of things, playing this game, doing this stuff, yeah, it seems like they're all 14 and their parents aren't paying attention, but they all are okay with it. So I guess that's just how we do things here. I mean, can we common sense say that there's an end zone, right? That at a certain point you get to a place where you can say, well, that's not okay. I don't care how okay they are with it, it's not okay. And in particular, that gets tough when you have fraternization, when you have personal relationships that develop at work, and it's this and it's that, and whispering this and saying that, and everything's all good until they break up. Now, I am not an expert in the area of human psychology, but I will say this. It seems to me that people tend to be in love with each other and enthralled with each other right up until the moment when they're not. And that next part can get really ugly. I don't know if you've picked up on that, but I've picked up on that in a lot of different areas, not just workplace, but just in life. It's an ugly thing. So here's my question to you. We're letting objectively unreasonable things go because we've got maybe 2 people that are willing participants. But then one day somebody says one night, well, I'm done. I'm done. I don't want to be involved with this anymore. And the other person persists. Well, now what? We flip the switch and say, well, we allowed it before, but now all of a sudden we're going to put a stop. You see the precarious spot that puts people in, how untenable that is as a standard? I think that's something that's common sense. I touched on the idea of are you, particularly as a supervisor, as unfiltered at work as you are at home? Again, to be clear, I'm not suggesting that we need people that have multiple personalities, that you're completely unrecognizable, but there's some thoughts that you might have that you just want to hold on to and not let them go out your mouth, right? Not act on them when you're in the workplace, where if you were at home, maybe it would be a comment. I mean, it's just common sense stuff like that. The activity in question has a well-known nickname, indicating that it's pervasive, it's routine, and it's widely known. If someone has a nickname, if the activity has a nickname, that's problematic. The only defense that's available is that the complainant, the person that's now coming forward and saying this is a problem, well, wait a minute, they were smiling as much as anybody. They were laughing, but they were playing along as much as anybody. I've got to ask you a question. We had the holidays not too long ago, right? Thanksgiving dinner. Were there some people that had to do some awkward smiling and laughing? Why? Well, because what Grandma just said is not okay. What Grandpa just said is pretty messed up, but we don't know if this is his last Thanksgiving, and you're uncomfortable, and you kind of smile, but that's not okay. So the idea that, whoa, smiling, oh, well, that's ironclad. And by the way, good luck to you finding that as an effective defense in lawsuits, to say, well, no, you smiled. You smiled. You smiled. You don't get to sue us. You smiled. No, That's not what we're seeing. What we're seeing actually is that judges, people in the community have a common sense understanding that we have all been in situations, either at work or at Thanksgiving dinner or somewhere in between, where you smile, you laugh uncomfortably. And you're nauseous, and you kind of smile and you laugh. It's uncomfortable laughter. I mean, there's a reason, there's a term for that. You know, it's an uncomfortable laughter. You kind of laugh, you kind of smile because you got 5 people that are engaged in this. They're having a good time, and you're not on a mission to put a stop to it. You don't really know what else to do, and you want to have a decent working relationship. And isn't that really at the heart of what we're talking about? You shouldn't have to choose between having a good working relationship with the people that are around you and tolerating things because it's majority rules. It's not how it works. There is an objective standard here. That's what you've got HR folks and attorneys in the city getting at. And this is particularly true, by the way, when we've got a higher ranking department member that was present when the activity, the statement, whatever the case were, was going on. They were laughing too. Does common sense dictate that people in uncomfortable situations smile or engage in awkward laughter as a way of conflict avoidance? Again, that's my Thanksgiving example. What if the conduct is objectively offensive and the person in question stops laughing? Doesn't that mean we all had knowledge and failed to act? And here's the other tricky thing, and I'm jumping ahead a bit. There is a responsibility. If somebody says, look, this is what my coworker is doing when we're out, we're working in the parks, when we are working, whatever the environment is, whenever we're out there, you know, this person's saying this, that, the other. Okay, and they've been doing it for the last 10 months, so I'm just going to go ahead and sue you. Well, it's very clear that no, basic fairness, as well as the legal guidance that we have, says no, you have to give the city a chance to fix it, right? If we genuinely didn't know, not looking the other way, not the supervisor was present, was aware of it, but if we genuinely didn't know and it was an isolated type of a thing, you have to give us a chance to fix it. You have to give us a chance to separate the two, investigate it, figure out what happened. You have to give us a chance to do the right thing. That's why you have, you know, many cases where something horrific happened, something god-awful happened, something that really is actionable as an assault happened, and yet you have an organization, a department that isn't sued. Plaintiff's attorneys won't take the case. Why? Because they genuinely had no idea that anything like this would ever happen. There were never any indications that this would happen, and when it hit, they did the right thing. They separated, they investigated, they terminated. Okay, well then there's no lawsuit there because they did everything right when given the chance. With all that said, that becomes really difficult to put forward as a defense, either from an ethical standpoint or from a legal standpoint. When you have all of a sudden, well, it was okay, it was accepted, the person stops laughing, and if you're the supervisor, they don't have to come to you and tell you what's going on if you're in the room. I hope that makes sense. If you're seeing what's happening, if you're either perpetrating or you're seeing what's happening, they're not required to come up to you and say, hey, I don't know if you were asleep with your eyes open while you were nodding and smiling, but I'm going to, just in case you were, this is what happened yesterday. This is what's been happening every day for the last 3 weeks, right? There's not an expectation that they do that. So this whole they were laughing too thing is not as relevant as so many people seem to think that it is. What about a common sense analysis when the complainant is a witness? So that example I gave where, yeah, they may be okay with what's going on over there, but I'm not. I didn't sign up for this. I thought I was working for the city. I didn't know it was going to be party time, right? I didn't know that this is kind of stuff where, I don't know, I'd be uncomfortable at a party, but certainly I'm uncomfortable at work to have to watch this. Is there objectively unreasonable conduct that employees should not have to view and tolerate and put up with in a professional setting? You know, God knows it's tough enough to get good at a job. It's as I touched on, there's a lot of challenges in the workplace, tasks that you don't feel like doing, you know, upset community members that you're trying to deal with, all different types of things. And what this is all about is, okay, so we expect our people to professionally handle all that. We don't expect them to put up with this. The direct target is not necessarily the only person affected by the conduct. You know, could the conduct become so bad that somebody says, I don't know if I want to work here anymore. I mean, I come in every day and this is going on, that's going on. They have this game that they call blah, 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 blah. And so they do that all the time. And I'm just trying to do my job. And, you know, all of a sudden I'm the narc here, I'm the hall monitor. I don't think that should be the spot that I'm in, right? I don't think I should have to put up with this on a regular basis. That's why I'm coming to HR. That's why I'm coming to my supervisor. I just don't think this should be going on. That can be a very legitimate claim under in particular, the policies that we're talking about, under your city's specific policies. You know, it's parallel to the myth of not pressing charges in the criminal world. You know, law enforcement routinely brings charges where evidence is present, even if the victim sides with the apparent perpetrator. So in other words, you've got a situation where, in many cases, I'll give you one that's as common as any, possibly the most common, which is a domestic violence situation. This happens in law enforcement all the time, where there's evidence that there was an incident of domestic abuse, and the spouse, the significant other, says, "Well, I'm not pressing charges. I love that person," and we could go into this. We certainly don't have time to talk about the difficult and tragic cycle of violence that the law enforcement community struggles with and the prosecutors struggle with in the context of domestic violence. But putting that aside for a second, there's cases where he beat you, he threatened you. We walked in, we saw what we saw, we heard what we heard as law enforcement officers. We're charging him. Okay, yeah, but I'm here to tell you I don't want you to charge him. I understand that, but we're charging him. Why? Because he committed a crime. And we don't have laws that say at the end of them, right, state statutes in Kansas at the end, comma, unless the person's okay with it, period. Oh, okay. No, it doesn't matter if they're okay with it. It doesn't matter if they say they're okay with it. It doesn't matter. In many cases, you have prosecutors who have a hostile witness in the victim. I mean, this is what happens. But the question is, what does the law say? What are our standards of behavior? Now, the parallel here is, if our standards are, we don't allow harassment, we don't allow this type of over-the-top vulgarity, discrimination, targeting, we don't allow this stuff. And even if the person who is the target says, no, I don't think it's a big deal. I think that this third person is making a mountain out of a molehill. Our big question, if we're the HR folks there, if we're the lawyers, the big focus is, well, what happened? What happened? And is that reasonable? What happened, and is that okay? That's the fundamental question. It's not about, is somebody ratting somebody out, is somebody stepped. No. All that nonsense goes away, and the question is, does it violate the policy? And if it does, the source of the information is not really relevant. Is it the target, or is it someone that's a third party, a witness to it? In either instance, we really need to look at what our responsibilities are as a city, and that's going to be the analysis. Now, the key harassment policy components, and I think that you see this in Manhattan, definition of and stated opposition to unlawful harassment. Also, guidelines for reporting harassment and communicating that retaliation for lodging complaints will not be tolerated. And that's something we really want to focus on, because when someone comes forward, it's almost sort of like a whistleblower type scenario. When someone comes forward, they have a right, a deference, the benefit of the doubt, if you want to call it that before we assume that this didn't happen, we've got to be very careful, because we don't want to have a chilling effect, right? We don't want to have an effect where at the end of the day, people feel like if they come forward, they're going to be retaliated against, right? They're going to be in a situation where their work environment is worse than it was before they reported. If we are genuinely going to engage in this, and we want to encourage people to, if you see something, say something, to step forward, that's something that we want to definitely focus on. Retaliation analysis, here when we talk about in the legal framework, if someone in your 10th Circuit shows, look, I engaged in protected opposition to discrimination, that's harassment, gender discrimination, etc., and then something negative really that affects my work life happened, and there's a connection between the two, that's something that is unlawful and can be every bit as damaging financially, every bit as damaging in terms of a time-consuming lawsuit as the actual discrimination, the actual harassment itself. And in many cases, we really see that being the source of the liability. The source of the liability is not so much what happened, but someone saw what happened, someone was the target of what happened, they came forward, nothing was done affirmatively, and in fact now they're working a less desirable shift. Now they're being given and again, I'm trying to keep this broad because I know we've got folks that have different job titles in different departments, but now we've got that least desirable thing that we sort of spread around, people sort of take turns. Now that's what you do all the time, right? Now your job life has really gone downhill. Well, that appears to be retaliation. And that retaliation is something that we want to take very seriously, again, from an ethical standpoint, from a this isn't how we do business standpoint, and also we want to take it seriously from a liability standpoint, because retaliation claims can survive while even that underlying discrimination harassment claim is dismissed. So again, getting back to that standard, you could have a judge that says, or judges that say, you know, this is not bad enough to be discrimination. This is not bad enough to be harassment, sexual harassment. Just isn't that bad. But they were acting in good faith, and I want to be very clear on this. You don't get to lie, right? That's something that we're going to talk about a couple of times during this webinar. You don't get to lie and get this protection. But if you're acting in good faith, if you're being truthful, and a determination is made either internally or the determination is made by a judge that, well, this is not great, but it really isn't something that rises to the level of something actionable. You know, maybe this is a knock it off moment. You know, there needs to be a verbal reprimand here. That's what we're really looking at. Even if that's dismissed, and even if it's found, well, the underlying claim didn't really have the merit, but they were acting in good faith, they weren't lying. And on top of it, after they came forward, now all of a sudden they're working that undesirable shift. Now all of a sudden their office is a broom closet, right? Now all of a sudden they're seeing their job prospects take a nosedive. Well, that's the retaliation that we're talking about. That's the retaliation that can trigger as much liability as anything else. Really sort of an extreme example of this, we've got this Magiera case out of Dallas. This was a police case. And the long story short on this is we have a sergeant who files a Title VII sexual harassment lawsuit. The reason that that's filed is because this individual was on a call and a sergeant referred to her as Darlin. In the course of a conversation, said Darlin, touched her on the shoulder. After it was sort of a debrief coaching thing. Hey, good job handling that call. A lot of drunks. You know, you really kept your cool. That's good. You know, you really de-escalated that. Blah, 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 blah. But in the course of it, touched her on the shoulder and called her Darlin. Now, I'll give you my 2 cents on this because based on the case facts, she was isolated. The sergeant had never engaged in anything like this before, had never targeted her, and in fact, Officer Magiera acknowledged that. She acknowledged that in deposition. He's never targeted me. I didn't feel that this was a sexual advance. I just thought that it was inappropriate. I didn't think he was singling me out. So that, to me, is a classic example of that lieutenant over that sergeant saying, listen, sergeant, here's a conversation I don't want to have again. Don't call another member of this department Darlin. That's not your daughter. That's not your wife. That's not your niece. You're not at home. Right back to that example. You're at work. That is another member of this department, a sworn member of this police department. No more Darlins. Are we good? Okay, let's not have this conversation again. But a federal lawsuit, well, of course, that doesn't pass muster from a liability standpoint. I think there's a strong argument to be made that an isolated incident like this, again, I'm all about a knock-it-off conversation being held, but that this would rise to the level of real discipline, to me, seems like a real stretch. With that said, why is it that this was a year-long, multiple years long, I should say, lawsuit? Well, because after she filed this underlying discrimination claim, this sexual harassment claim, she was taken off of FTO duties, field training officer, which meant that she had less authority, less oversight responsibility, and she lost a bonus that she got once every year. So there's financial loss and there's some reputation loss, some climbing the ladder loss. So that's what she brought forward. And when she was in court, or when I should say her attorney was arguing for her in court in the Fifth Circuit, the issue of, well, what about the sexual harassment claim? That wasn't valid. That was completely left to the side. That attorney said, don't want to talk about that. We'll concede that. There was no sexual harassment. But my client spoke honestly. She believed that it might be harassing behavior. And as a result of that, she's taken off FTO duties 3 days afterwards. That's not a coincidence, right? That's a correlation. That's retaliation. That's something that has a chilling effect. And that's something that needs to be looked at, and that's what really becomes the damaging part here. Complaints must be specific. I want to make sure that we talk about this. People that are sort of complaining, venting a little bit about their jobs, I don't want every supervisor thinking that any complaint is necessarily one that sort of triggers the alarm bells. I'm not getting enough credit around here. I'm always the odd person out in the department. My boss doesn't appreciate the work I do around here. I would suggest to you a follow-up question to that, which is, okay, well, why do you think that is? You know, and I would even say, as an attorney in this area, I don't think there's anything wrong with if they're really sort of leaving you at a loss. Are you saying it's because of your faith, your race, your gender, right, or whatever factor it might be? I'm getting a feeling like maybe that's what this person is telling me. To ask them, well, listen, I'm sorry that you feel like you're not getting appreciation around here. You know, I'm sorry that you feel like you don't get enough credit. I get that, but the way you're talking, I'm a little confused. So I have to ask you this. Matt, are you telling me you think it's because of your faith? Do you think it's because you're a veteran? Do you think it's because, whatever that is? Is it something like that? What is that what you're telling me? Because if it's something where you're being targeted in particular because of something that has to do with, race, gender, sexual orientation, I got an obligation there definitely to kick that up. And if the response is, well, no, I'm just, he's just kind of a pain. I just feel like he's just, he needs to go to a leadership class. I just feel like he doesn't really, reinforce us enough. He doesn't really, everything's negative. He notices when we screw up, but doesn't notice when we do something right. Okay. Now we're in a different area, right? Now, I know it's not always easy to draw that black and white line, but I think as supervisors, you want to do the best you can to figure out, am I dealing with somebody who's bringing forward a harassment claim, a discrimination claim, or is it somebody that's just saying, I'm not liking the way that the team is working, which certainly you're going to have those conversations. And I don't think that those need to, in all instances, be kicked up. Now, a verbal complaint can constitute protected expression. Let's be clear about that. Also, assisting, testifying, cooperating in a relevant investigation, those are protected. So, in other words, these are the ones where if we're conducting an internal investigation, if you've got your city attorney, your head of HR, whoever it might be, who's bringing someone in and saying, well, person A is saying that person B is engaging in activity, saying things, doing things that person A finds to be really offensive, some harassing behavior. Have you seen anything like that? You could have somebody that says, well, yeah, I do know about that. I mean, I did hear person B say that. I wasn't particularly offended. I didn't, think it was that big of a deal. But yeah, I mean, that happens. Well, how did you think person A felt about it? I could tell person A was pretty upset. I could tell person A felt really awkward. I felt kind of bad for person A, but I didn't think it was that big of a deal. I didn't really think I needed to get HR or legal involved in it. Okay, what has just happened is also protected, right? That person, now we've got to be careful and make sure that we don't have somebody that's cooperating in an investigation and is saying, yeah, I saw that. Yeah, I heard that. And now all of a sudden they're in the broom closet, right? So you want to make sure that protected expression understanding extends beyond just the person who's potentially the target to folks who might be just participating in an investigation and just telling the truth as they see it. Can I tell you something not as my sergeant, but as my friend? I'm going to hit this note, and then Justin, if you don't mind, we'll take a quick stretch for a fresh cup of coffee here. But can I tell you something not as my sergeant, but as my friend? This is one that I get in various phraseology all across the country. It's very similar to this. One thing I'll say as a beginner, to start off with, again, I'm not on a vendetta to stop people from socializing with subordinates, but I will tell you that it is very regular that I get real messy facts to me where it's, well, I think, all right, we were all drinking, we were at the pool party, it was happy hour, it was trivia night, and I'm there with my subordinates, and we were all, drinking, and then somebody said, I need to tell you something about so-and-so, and yeah, I thought maybe that was sexual harassment, but I don't know, it was in the setting, it was a work thing, they were talking about work, and they were saying at work this happens, but I don't know, it was kind of awkward, and I felt like, it was just sort of an off-the-record type of thing. You don't want to be raising your right hand in a deposition or in court and saying, yeah, they did tell me that, but it was Margarita Monday. And, I thought I had the Margarita Monday defense. No, it doesn't work that way. And also, I would tell you that, can I tell you something, not as my friend, but as my sergeant, not as my sergeant, but as my friend, not as my supervisor, not as my, you name it, right? Not as my boss, but as my friend. The answer to that's a pretty easy one. No. Because whatever is coming, 99 times out of 100, whatever you're about to hear is something that is going to put you in a position of conflict, right? As a supervisor and as a friend, it's going to get ugly. So as quickly as you can, you want to jump in and say no. So again, first point I would make is I don't know that I'm in a position to say you should never socialize with your subordinates, but I will tell you there's a lot of people that say, yeah, when I made supervisor, trivia night, that trivia team lost a team member because I just don't want to be a part of that. Nothing good is going to come from that. Okay. You make your own judgment on that. Is there a lot of indication there that leads to some problems? Yes, but I'm not on a vendetta. But even more importantly, in the work environment, we're friends. Yeah, we started about the same time. We know each other. Our kids play Little League Baseball together. Got it. So we are friendly. Okay, completely understand that. But I want to tell you, I'm going to tell you this just as a friend. Folks need to understand, if you're telling me as a supervisor something work-related, I can't take off my supervisor hat. I can't take off my boss hat. If there's something going on here, I don't care if it's what we're here to talk about, a sexual harassment issue. I don't care if it's, hey, not for nothing, but, so-and-so is showing up to work, and I think she's under the influence, which is scary because, she drives a truck. So that's not great, right? I can't just say, well, I pinky swore that we were friends, so I'm just going to put that under my hat. Get out of here. You can't do that. When we're talking about safety issues, when we're talking about these other issues, you don't have the ability to simply say, well, we're gonna just put that under our cone of silence. We're gonna put that under our friendship umbrella. And I hate to sound maybe flippant about that, because I understand that there are folks out there that genuinely get put in a tough spot. But at the end of the day, that's not something that we can allow. And in many ways, it's similar. Can I tell you something, not as my supervisor, but as my friend? I'll tell you this again, whatever's coming is not going to be an easy one. It's one of those things. It's like someone saying, hey, let me tell you something. Promise me you won't get offended. I cannot promise you that. Right? I can't promise you I'm not going to get offended. And the fact that you're wanting that promise indicates to me that there's about a 99.9% chance that it is going to offend me, right? That it is going to put me in a tough spot. So when we have supervisors that have friendships, certainly that happens, and that's not the end of the world. But we want to make sure that supervisors recognize that, look, when you put on that supervisor hat, when you step forward and you say, I'm going to take the responsibility, the added pay, right? I'm going to move up the ladder of this organization. That there's multiple facets of that. And one facet is it becomes very difficult all of a sudden for you to be able to hear things that you as a supervisor have an obligation to be on top of, to be aware of, to act on, and in many cases, kick to HR, kick to legal, kick to your supervisor. When you do that, are you sacrificing something? It's like everything else in life. Well, yeah, you're sacrificing a little bit. And I can't tell you how many supervisors I've met, leaders I've met, who've said every time I got promoted, it was like I lost a good buddy, because all of a sudden it was tougher to be friends with people. I don't think that those are sadistic people that don't value friendship. I think those are people that realize it gets really tough when you're supervising people to be friends in the way that you were when you were just a couple of firefighters, right? When you were just two dispatchers, when you were just two people working, starting in Parks and Recreation, you just started out. That's one thing. But once there's that supervisory relationship, it does get tricky. And I don't want people that were in one another's weddings and godmothers and godfathers and people that are close. Personally, I'm not trying to break up a bunch of friendships, because that's certainly an important thing. But just be mindful that a lot of this gets really ugly when it's all brought out that there was a pattern, and now you as the supervisor were aware of it. And that defense of, well, that was as a friend, not as a supervisor, not a very effective one. With that, Justin, are we good to take a quick break here for a fresh cup of coffee?
Absolutely, Matt.
All right, thanks, Justin. We'll jump right back, folks. We'll go ahead and stop the recording, pick right back up. Thank you. Okay, thank you for that, Justin. Appreciate it. Let's get back into this issue of adverse employment action. Don't want to spend too much time on this, but just to underline what I think is reflected in the mission statement of the Manhattan Policy and Procedures, what's been stated by the courts. When we talk about adverse employment action, sometimes there's a misnomer that, well, no one got fired, no one got suspended, no one's pay has been affected by this, they haven't been demoted. So that means that there wasn't any retaliation. This can be shifts, this can be assignments, this can be on a day-to-day basis. What are you actually engaged in, the types of work that is more undesirable for whatever reason, and everybody knows that's the last, the short straw person has to do that. Now all of a sudden you're always being assigned that work. So when we talk about the context of retaliation and how problematic that can be, you want to keep in mind it's not all about dollars and cents. It's not all about an economic hardship. It can be a retaliatory action that certainly doesn't go to that extent financially, but is still really relevant to someone's daily experiences at work. Employers need not suspend previously planned transfers upon discovering that a Title VII suit has been filed. This is language from this Clark County School District Supreme Court case from back in 2001, and you can very easily replace previously planned transfers with discipline, demotions, terminations, and anything in between. So in other words, if you can show that, look, this is a coincidence. It's a coincidence that Matt came forward with this discrimination or harassment claim now. It's Thursday. He's come up with this. This has been going on for a very long time. And in fact, on Monday, I can show you that we had a sit down and we had a write-up with him and let him know that that this was another violation, that we've discussed this before, and that we're going to discuss whether or not he's well suited for the position that he's in. Something like that. So we can show you on Monday, like the train already left the station. But on Thursday, now he's maybe abusing the system. And that's something that I think we always have to talk about when we talk about harassment, discrimination, and it's something that's a very disappointing thing. But any time that you pass, whether it's a law or a policy that's entitled or intended rather to protect people that are all entitled to a reasonable workplace. When you see those that again are to be applauded, there's always going to be somebody somewhere that's going to try to abuse them, right? So you have to be mindful of that, and I think you have to recognize that and acknowledge that. And if we don't, I think that we're going to be putting ourselves in a tough spot, because there are folks, unfortunately, we refer to them here as toxic employees. It's amazing how many agencies have a very small percentage of people that account for the overwhelming majority of stress and strain internally inside of that department. And oftentimes, unfortunately, they become the frequent flyers that learn how to work the system. And working the system can mean a lot of things, and one of them is coming forward with less than genuine claims of discrimination or harassment. And again, I think that's something that I always end up hitting on to try to get everybody on board with this as best I can. Is there's two things that should be playing in simultaneously. One, we don't tolerate harassment, sexual harassment or otherwise. We don't tolerate discrimination. And if a complaint of that nature comes in, we take it very seriously. We investigate it, and we're on it. At the same time, if it's shown through that investigation that somebody is abusing the system, if they are trying to weaponize these policies, these laws that have been in place to protect people, that is a very infuriating thing. As seriously as we take the complaint, if it turns out that it was factually untrue, that things were being made up, and this was some type of a vindictive attack, or if it was a way for me to try to get out of trouble, to claim racial discrimination or this type of bias or gender, but whatever it might be, or national origin, if I'm utilizing that and trying to play a game with that, that's something that we should be very serious about. So I bring that up in the event that we've got folks that are watching this and saying, man, this retaliation stuff, it's like as soon as our problem person throws up that red flag, they're untouchable. We can't discipline them, we can't counsel them, we can't assign them appropriately, we can't do any of that. Well, that's not necessarily true. The question is, have you been documenting? Have you been having counseling sessions? If Dolan has been a problem for a while, have you sat down with them? Have you addressed it? If you haven't and the complaint comes, well, then we have a problem, right? It appears to be retaliatory, but if you're actually engaged in the process of counseling and identifying and documenting problems, well, then that's different. Defining hostile work environment, sexual harassment, again, severe or pervasive, created a hostile or abusive working environment, was unwelcome, and was based on the plaintiff's sex. And again, this is the legal standard, which I think informs, even though it's not exclusively about a legal issue, I think it does inform what we mean and what we look at when we talk about city policies and procedures. Severe or pervasive, again, that's either it's a one-time thing that was so over the line that alone is something that's legally actionable, or as I touched on before, something that is continuous, something that's on a regular basis. That can be every bit as expensive in terms of finances, in terms of time, in terms of the trust that you have within and outside of the organization. And also something that I would highlight here is unwelcome. And we're going to touch the very last slide. We're just going to touch head on the very difficult issue of fraternization. But that's another part of this, is that it was unwelcome. And sometimes if we don't have fraternization strategies, we don't have some way of, and you wonder, why is it that companies and cities want to know who's dating who? I can promise you it's not that we have attorneys and HR folks who are trying to be nosy and get in everybody's business. It's that we've got attorneys and HR folks who don't want this to turn into a massive lawsuit, and they don't want this to become a situation where, well, it wasn't consensual. We were in a relationship for a year, but this person was my supervisor and I felt pressured. Well, now it's, if you'll forgive the term, it's he said, she said, right? It's one person's word against another's. And that's really tough, as opposed to we can show you, well, no, they were in a relationship or they had an obligation to tell us they were in a relationship. So severe, pervasive, and unwelcome, I think, are two things that you really want to focus on. Sexual harassment is not limited to sexual advances. I know that you have a policy, I think, that fleshes out this distinction in its own way, but just something to kind of put in the forefront of your mind. there are a lot of cases out there where you have men that are using terms that I don't need to recite to you, but terms that are vulgar, profane, and are female specific. We all know what those terms are. There's multiple cases that are running through my mind now of defendants who are saying, well, yes, I used those words, but I don't find her attractive. I wasn't trying to make a sexual advance. That wasn't my intention. I didn't want to engage in any sexual activity. So are we good here? And the answer is no, because what you're doing is you're targeting, you're harassing, and when you start to use that type of gender-specific language, well, what does that suggest? The reason that you're targeting them, it suggests, is that they are of a particular gender, and that's why, right? That's why you're zeroing in on that person. So this idea that sexual harassment is all about, an overture, is all about a sexual advance where you're hoping to engage in some activity. Certainly that's a big part of it, but that's not the whole kit and caboodle. There's a lot of cases where you have sexual harassment claims that are successful, that should have been handled. I guess I could armchair quarterback and say that that department, that city, whatever the case may be, that county, they should have handled that better. And it doesn't come down to sexual advances. It comes down to we have harassing behavior, we have bullying behavior, someone's being made miserable, and we have some indication that it's because they're the only female in the group or in the on the shift. It's because gender-specific language is being used, it's because jokes are being told, where the punchline is because a woman shouldn't be working here or something of that nature that has a sexist connotation to it. Then all of a sudden we've got sexual harassment that may not be a sexual advance, but it's gender-based. And speaking of the gender thing, I think it would be disingenuous of me not to acknowledge the fact that the statistics that I see, the cases that I see regularly on an anecdotal basis, do indicate that the majority of instigators, the majority of defendants in claims of sexual harassment are male. I think it'd be a little disingenuous for me to act otherwise. At the same time, we have to be very careful because it is not exclusively men that are engaging in this activity. And I say this because we have to be cautious of something. We'll talk about Foster in a second, but if I could give you a law enforcement example. There was a Marine who had been discharged recently, went into law enforcement, and to really paint the picture of how this doesn't fit into your stereotype, he's 6'4", he's extremely strong, he's in great physical shape, very muscular build, so he looks like a linebacker, this guy, right? So he's this large, imposing presence, very nice guy, but just physically imposing presence. Looks like he'd be tracking down Tom Brady from the backfield on Sundays. So that's the new officer. The sergeant, who is his boss, is a female who's 5'5", maybe weighs 130 pounds or whatever it was, very petite individual, so not as physically imposing. And he's going to work, and at roll call, she's making comments about her guesses as it comes to his anatomy, making comments about his anatomy and what she'd like to do with this and what she'd like to do with that. So after a while, he goes to the higher ups and says, "Look, I just want to be moved. Just moving. I'm new here, and every day with this, I mean, it's embarrassing. It's humiliating, as an adult to have to go into work and she's in front of everybody making these comments, and there's been a pinch or two. It's just not okay. And also, this is the supervisor that is supposed to show me how I'm supposed to be working out here, right? I've been in combat, but I haven't worked in a civilian environment as a law enforcement officer. I got a lot to learn, and I am having a hard time looking to the supervisor for guidance when she's much more concerned with the sexual things. And it's just getting so old. So anyway, I don't want to cause a big problem, Chief, but if you could just move me." And the chief basically just said, "What, are you afraid of her? You think she's going to beat you up? She picking on you? No. Listen, you need to toughen up a little bit, okay? This is ridiculous. All right, look at you, look at her." That was a very expensive mistake for that chief to make. Now, what was the chief doing? Well, the chief was falling into this paradigm. I kind of hate to use that word, but this paradigm, this mindset of, well, what is sexual harassment? What's harassment? Well, harassment is something that a big, brawny, 6'4" male does to the 5'5" female, not the other way around. What he failed to recognize was, and was pointed out to him in a very frank way by that officer, "I'm not afraid she's going to beat me up. What I'm saying is, number one, she does my performance evaluation. She has a big impact on my career, so I'm afraid of that. It's not about, do I think that if we went out back and squared up and had a fist fight, do I think I could win? That's beside the point. What are we talking about? Secondly, I'm concerned because I just don't think I should have to put up with this. I think this is a stressful job. I love it so far. I want to do this. I have a passion to be in law enforcement, but I don't put up with enough. I don't have enough challenges, enough things that I'm trying to learn, enough ropes that I'm trying to navigate. On top of that, now I've got to have this supervisor who's making these comments, and none of that got through. So I think we do need to be cautious to sort of strike this balance, right? On the one hand, I think it's a little silly to act as if this is not something where we see disproportionately females being the target, but at the same time, it's not exclusively. If that makes sense, hopefully. So if you find yourself in a situation where, well, wait a minute, we've got the male saying that he's the one that's being the victim. Well, that's not how this works, is it? Well, it can be. Like in the case of this Foster v. Ohio Bell telephone company. What I think is interesting about this case is it brings up a couple of important points. One, we have a female manager. Two, we have a female manager who is making comments to this male subordinate, none of which in isolation I think are ones that would shock the conscience, would be severe enough to be actionable, but it's the straw that broke the camel's back, right? It's a continuous thing where she's continually hitting on him, making her interest known. What are you doing tonight? And he just doesn't know how many ways he can tell her that he's married and isn't interested. Then after a while of these unwanted advances and him deciding not to go over to her place, he's up for a promotion. She's one of 3 people that are in the position on the panel of deciding who gets promoted and who doesn't. 1 out of 3. He doesn't get the promotion. That was found to be enough by this Ohio court to say, let the jury decide. So in other words, we're not tossing this out, right? It's not summary judgment. We can't toss this out. It's a close call. Well, why? Well, because she's got she's a manager. She has some role in deciding how high he rises in this department, in this company, how well he does if he gets promoted. She's got some role, and she was continually doing this thing. We think there's enough there to say that there could be a causal nexus between him shooing off her advances and him not getting the promotion. Now, did she ever at any point allegedly say, this is going to happen or you're not going to get promoted? No. But getting back to that quid pro quo thing, as well as touching on this gender issue, they didn't need that. Really what they could say is, well, when you are a supervisor and you decide to make your interest known and to do all these things, you have to realize that you're treading on something dangerous here. And in particular, if you mix that with having some impact on this person's future, which you almost inevitably do, that's the real problem. You know, if you're a supervisor, you almost inevitably have some role in, does this person get good performance evaluations? What is this person assigned to do on a regular basis? What does this person get in terms of discipline that maybe somebody else wouldn't have gotten? You know, all these different allegations. So you go in knowing that if there's an advance that's made on a subordinate, particularly if it's frequent, if it's not one and done, but if it's continuous, that really is setting the stage for a quid pro quo sexual harassment lawsuit issue, as well as bringing this case up for the impact when we talk about female manager, male subordinate. And hopefully that story I told you from the law enforcement side of things made some sense. You know, again, we've got to get away from this idea that, well, it's about, you know, being physically intimidated. Well, that's not all that this is supposed to be about. It's the idea that there's multiple types of intimidation, and some of that could have to do with what's my future in this organization, and that can be every bit as potent, every bit as real and damaging as some type of physical threatening aspect of it. Now, if we switch over, what do the courts require of employers? And again, you know, the courts give us this foundation that I think Manhattan and other municipalities build upon. But it's pretty simple. Number 1, take reasonable care to prevent harassment, formulating and effectively communicating the policy. The types of things that we're hoping to do here, that your HR folks and your legal folks do on a regular basis, hopefully your supervisors do, to let everybody know these are the policies, this is where you go, this is what your responsibilities are as supervisors. That's half the battle. The other half is to take reasonable care to correct that harassment. So if something actually comes up, to quite simply put, follow your own policy. And as many of you know, that can be the most challenging part. It's one thing to come up with a policy that makes all the sense in the world, and it reads well and it makes sense. That's great. It gets, in some ways, more problematic when you have to then say, well, we've really got to follow through on this, right? We've got a lot on our plate, a lot going on, but we have an obligation to make sure that the supervisor is doing the right thing, that we're doing the right thing as higher ups and investigating, et cetera. So these are really, you know, fundamentally what the courts are required. Again, I want to touch on the duty to report harassment. They have to give us an opportunity to do the right thing. So I don't want anyone walking away from this webinar with the idea of, I have got to be a detective. I've got to be constantly on the lookout. I've got to go out of my way. I've got to do things that I would not normally do in the course of my obligations as a supervisor to see if there's anything going on. Now, that doesn't mean that you don't, make common sense inquiries or ask somebody a question, but I don't want you leaving with the impression that it's your obligation, especially if you're some supervisors, they find this. You're in a situation where, geographically speaking, your people are spread out throughout the city, and they're working, and you're not working every shift, and they're different places. It's just not logistically plausible for you to constantly be supervising everybody. I don't want you walking away thinking, well, this means that I'm on the hook, the whole department's on the hook, and everything's going to come crashing down, and I failed if I don't sniff that out. Because there is an obligation on the part of the employee. It's a two-way street here. There's plenty of circuits have formulated this, and the 10th Circuit certainly has. I do like the way that the 7th Circuit formulates it. It's different ways of saying the same thing, but I think their phrasing is pretty solid. While a victim of sexual harassment may legitimately feel uncomfortable discussing the harassment with an employer, that inevitable unpleasantness cannot excuse the employee from using the company's complaint mechanisms. So when we let you know, you can go to HR, you can go to your supervisor, you can go to legal, whatever those different avenues are that your city sets up. When we make it clear, where do I go? And by the way, that unfortunately is sometimes the most difficult part of communicating a policy. Okay, if the supervisor is the one that's engaging in the harassing behavior, or if the supervisor knows about it, is in on it, is laughing about it, who do I go to? Sometimes that, nuts and bolts, not big sweeping statements about, why harassment's so bad. Sometimes the most challenging part can be, well, who do I actually go to, right? What are the mechanics of this? How do I actually make sure that this is being known? So we want to make sure we have that in place and recognize that if there's harassment being engaged in, that's unacceptable. But you have to give us a chance. You have to give that supervisor who's saying, I've got all these hundreds of square miles to cover, I've got all these different employees, and you're not telling me. You're not telling any of the higher-ups. You're not, and we have in the policy that you can come to these different, you have to take advantage of these multiple avenues that we've laid out for you. You have to make sure that you take advantage of those, and if you don't, we can't take action until you make us aware of it. And again, it has to be not a disingenuous denial, not a plausible deniability game of, I don't want to see that, I'm going to make an effort to not see what's there, but someone who genuinely says, I've got a lot of people that work for me. They work all over the city. I didn't know this was going on. I didn't know this was going on. Got a lot of people working for me. So now that you brought it to my attention, before you go to court, we have an opportunity internally to do the right thing, right? We have an opportunity internally to take a look at our policies and say, well, what are we doing here? Here we have from your policy, any employee who believes that he or she has been subjected to sexual harassment should report the alleged acts or conditions immediately or as soon as possible to his or her supervisor. If the employee prefers, for reasons of sensitivity or confidentiality, or if the complaint involves the employee's supervisory personnel, he or she may report the complaint to the director of HR, the HR specialist, or to any supervisor or any department head. Or department head. So here, what are you seeing? Multiple avenues. You have multiple opportunities to go through, and if you don't see the action that you need from the first person that you talk to, there is an obligation that we see in the court case law, I should say, in the case law, of continuing to take advantage of, well, you have to now you have to go to the head, now you have to go to the department head, to give that as an example. I went to my supervisor, I felt comfortable, but she just brushed it off. Well, maybe I'm going to go to the department head, maybe I'm going to take advantage of these multiple avenues. I think that's an important thing to keep in mind. Also, if we go back just a minute, I used the example of the two steps there. You have to have a plan in place, preventative action. Have a plan in place, have a policy, communicate it, and then there's a corrective component of it. Well, you look at this Pinkerton case out of Colorado in your 10th Circuit a few years back, and the 10th Circuit found that, look, the parties don't contest that the Colorado Department of Transportation, that they unreasonably failed to prevent harassment of a sexual nature, right? They had a policy. The policy made sense. It prohibited sexual harassment, talked about what it was, identified the complaint procedure. This all sounds great. Requires its employees to take a 4-hour sexual harassment course, identifies the behavior. They did all these different things. It all sounds great. The problem is the actions reflected reasonable care as report of harassment was immediately investigated. As soon as the investigator indicated that the plaintiff's report might have some validity, her supervisor was promptly reassigned. So what they really hit on here was, well, how do we do this thing? What's really the goal? Number one, they had preventative measures, but here's the real tricky part. They actually followed through. And I don't say tricky to make it sound like this is some Herculean feat, but so many agencies they hit that first one, just like CDOT did, but they don't actually take on the prompt reassignment, the prompt separation. We've got to separate, we've got to investigate. And this illustrates the duty to take advantage of multiple avenues for reporting harassment to trigger liability, because in this case, you had someone that came forward that said, I've been subjected to this harassment for a long time. If you'll allow me to toggle back here for a second. The plaintiff in this case said, I've been subjected to this for a long time, so I'm going straight to federal court. And what the court said is, but wait a minute, you reported it, and once you reported it, you had the supervisor promptly reassigned, they began investigating it, and then you went right to court. You have to not give them years to figure out what to do, but you have to give them an opportunity to investigate and find out what we actually have, right? Give them an opportunity to do the right thing. Now, when we talk about doing the right thing and investigating, one key thing, and we see this in many internal investigations, whether it's public safety, whether it's the city, the county, the state, pump the brakes when jumping to conclusions regarding the validity of harassment claims. Stick to your procedures. In other words, it is a very human reaction to say that you have an opinion, especially if you're close to the situation, especially if you're in a situation where you have some personal knowledge of the work habits, the history of person A and person B. You may think very highly of the person that's being accused of engaging in unacceptable behavior, and you may not think a whole lot of the person that's the alleged victim, the alleged target. That happens sometimes, and you're a human being, and so you may have those thoughts. The challenge is, how do you fight that, right? The challenge is, how do you prevent that from actually negatively impacting the investigation? And I don't know of a better way than to say we need to pump the brakes, right? I don't know of a better way than to say, if we've got a situation where somebody comes in and they have a complaint, we have to assume that there could be validity to it. We have to look at this with fresh eyes, as much as that may be difficult to do. Doesn't mean that you completely put all that baggage of your own personal opinions completely in the background, but to the extent possible, you have to. And to the extent possible, you want to pump the brakes. Don't jump to conclusions. We want this done as quickly as possible. Excuse me, but we also want it done right. And that becomes really difficult, is because sometimes there's this rush to get the thing done, and we don't take the time to do it the right way. And I think that that's something that is easy for me to talk about on a webinar like this, but in practice, it can be very difficult to get people to hang in there with you as you engage in an investigation that takes longer than anybody would like. Another key point, never mind. Never mind should not suffice to conclude the investigation for a number of reasons. One, you told us something serious, we're taking it seriously. There's no takebacks here. There's no, well, the more I think about it, no. You said there was harassment here, and we're investigating it. We're doing right by you. We owe it to you, and we owe it to the whole department beyond showing it to you. We owe it to the whole department, the whole organization, to follow our procedures. We can't have something where when somebody says, oh, well, never mind. The more I think about it, it wasn't that bad. Did they feel pressured to withdraw that complaint? Because that's something we might have to discuss in court later. Did they have to choose between a job benefit and pursuing the complaint? Did they feel that pressure from somebody? The investigation's begun. I'm a big believer, as simplistic as it sounds. Once the investigation has begun, we have to come to a conclusion based on where the facts take us. We have to talk to people. We have to interview them. We have to find out, to the best of our ability, did this thing actually happen? And if it actually happened, how serious was it? What's our next step? We can't start, stop. Here's a real tough one for you, too. What if the complaint comes in Monday? On Wednesday, it's never mind. Then on Friday, it's, oh, before the weekend, you know what? That was messed up. And he did it again. That's stop and go, stop it. That's no way to conduct an investigation. Once the investigation's done, no, it's going to conclude. It's going to conclude when we can either find that it's substantiated, it's unsubstantiated, or it's unfounded. Now, that's language that I'm using. There's different language that you may use in Manhattan, but the bottom line is, can we show that it happened? We say this happened, right? It was unacceptable. We can't reach a conclusion, which is frustrating, but sometimes the water is very muddy. Or we say this was unfounded. Not only did this not happen, but actually it was unfounded. This is something where someone has given us statements, the complainant gave us statements that are not consistent with the truth, not consistent with an objective reading of the truth. And again, we have to be very cautious about retaliation here, but if it's at the end of the investigation, if we pump the brakes, And if it turns out that somebody who is not a great employee, someone who is prone to problems at work, someone who is prone to abuse the system, if it turns out that maybe we had a thought on that front and we were correct, well, if we can show it, that's very different. That's not the same prejudicial nature that I think you would argue occurs if somebody just makes a snap judgment. The investigation takes a day. You don't really dig in too deep because you already have the answer, right? You already know that this is not true, and then you're taking action that's negative towards the individual. That's not what we're talking about. What we're talking about is a genuine investigation, looking in to what happened and saying we can show that this was unfounded. This was just completely unfounded. And we always have to keep in mind, as I touched on before, we have to do two things at once. We have to take these complaints very seriously, but we have to let folks know that it's got to be a two-way street. We take it seriously when you bring it to us, but you're grown-ups. When you bring it to us, you don't get to fabricate, right? You don't get to make things up to make the story more interesting. You have to be honest with us. If you're honest with us, then we have an obligation to see this thing through, and retaliation shouldn't occur. But if there is an unfounded finding, right, if it's found that there was actually false statements given, well, then that's an issue. You hear this a lot. Whatever happened to innocent until proven guilty? And really what's behind this is we have somebody who's alleged to have engaged in this behavior, and now they have to work the night shift, right? They get moved. Well, why do they get moved? Well, because of the reasons that we touched on before. Hopefully this helps to break through a little bit, because I hear this a lot, and I think that there's this frustration, and I can understand where the frustration comes from, but this frustration that, you know what, we've got people who just being accused is enough to get you on the night shift, right? Just being accused is enough to get you in an undesirable spot. But the reason we do it is because we can't move the complainant, the person that's come forward. Why? Because that looks just like retaliation, right? Here we have someone who stepped forward. I'm experiencing something that's not right. And we say, okay, great. Well, we're going to move you to night shift. Or we're gonna put you in a closet somewhere and have you staple stuff until we figure this out. Well, then that person could justifiably say, well, this feels like punishment. Now, there is not protection against somebody saying, well, I was retaliated against because I was alleged to have engaged in inappropriate behavior. Well, yeah, there was some negativity there, and that's not statutorily protected. It's not protected by the policies and procedures. We hope that doesn't happen. But if it does happen, the time to resolve it is through the investigation to see where that takes us. And again, if it's shown to be demonstrably false, I really want to hit this because I think that this is an important component. In my humble opinion, if we're not careful, we draw a picture where it's just a one-way street. The allegations comes in, and if a finger is pointed at you, you really need to buckle up. You need to buckle up. You might have a really hard time here. You're going to be scrutinized. Now, if we scrutinize it, we find that there's nothing to it. Not that it's unsustained, not that it was something that this is a coaching issue and not a discipline issue, but if it's shown, wait a minute, this person was fabricating this. This person, we have evidence here. This person is being vindictive. This is about a relationship gone bad. This is about other things. This is about, I mean, Lord knows, this is about somebody's in-laws broke up with somebody. I mean, whatever reason, this person is trying to ruin this person's career. We find that out. We got to take that seriously too. And if we don't let everybody know that, I think that we fail to get the buy-in that we want from the supervisors, the leaders, the rank and file people inside of organizations to know. At first blush, what does it look like? Yeah, it does look like we're not following the innocent until proven guilty, but it's a different standard. It's a different environment. It's a different legal framework. It's a different policy framework. It's really not the same type of scenario. So we are moving that person now, but we're conducting an investigation in good faith. And if they are innocent, and again, innocent doesn't mean, well, who's to say we can't really come to a conclusion, but innocent as in we've talked to everybody that was there. We've looked at some work emails, all the rest of it, and we can show that this person was being vindictive. This was someone who was innocent, right? Not guilty, but innocent. We can show that. Well, then I would argue that we need to then turn that investigation around onto the accuser, and now all of a sudden the investigation is about falsifying claims against a fellow member of this organization, which is something that we take seriously as well. Again, I'll say, hopefully for the last time, I don't think it's possible, genuinely, if I can be real frank with you, I don't think it's possible to say we are very troubled by complaints of sexual harassment. But at the same time, if there's false claims, demonstrably made up, fabricated, vindictive complaints, it doesn't really bother us that much. Sorry, folks, I've thought on this a lot. I don't think it's possible to have that. I think there's somebody being disingenuous. So you're outraged by sexual harassment complaints when they come in. The idea that there's actual sexual harassment, that bothers you. That makes you want to pound on the table. That is not how we do business, right? Right. I'm with you. I'm with you 100%. But how can we then turn around and say, well, if it's found to be fabricated, if it's found to be a bunch of lies, we say, oh, well, wait a minute. I can't be upset about legitimate claims and not be upset that you, because you've got some vendettas to settle, because you've got some personal problem with somebody, you're going to take our policy, you're going to take the legal protections, and you're going to take them for a spin to try to mess with somebody's career. You're going to take these laws, these policies that were created to protect people, and you're going to weaponize them. Well, that bothers us too. I think it is two sides of the same coin, and I don't think it makes sense to have one without the other. And that's something that I think is really addressed in the policy that Manhattan has. False complaints, intentionally submitted, will also be subject to disciplinary and corrective action. It's a short statement, but it's a powerful one, and it's one that I want to highlight because I hear from so many folks, well, it becomes a witch hunt, and it's people being accused. To try to assuage some of those concerns, if it's a false complaint, if this is intentionally false, they will be subject to disciplinary and corrective action, just like someone who engages in harassing behavior would be subject to disciplinary and corrective action. So I think that's something positive that you should really take away from your city's policy, which is it explicitly acknowledges that this is a two-way street. Maybe it's not phrased that way if you'll allow my phrasing, but this is a two-way street. And we take disciplinary and corrective action when necessary if someone is subjected to harassing behavior or if someone takes our policies for a spin and tries to engage in a intentionally false claim. So I think that's something that you really want to focus on. As we start to wind down, I would say that the fraternization and sexual harassment, something that, and again, this is a real topic. People meet at work. There's a lot of people that have met and they have children and they've been together for 30 years and they'll ride off into the sunset together. And I'm not out to say that people shouldn't meet at work and that's a problem. That's where a lot of people meet. That's just the reality. At the same time, we have to be aware that this can go bad on us. This can go sideways on us. Your 10th Circuit stated years ago in the Windsor case, a person's private and consensual sexual activities do not constitute a waiver of his or her legal protections against unwelcome and unsolicited sexual harassment. So what's the takeaway there? See, there's a confusion here sometimes that, well, for months I thought that A and B, I thought these two were together. Right? Didn't I hear that? Didn't I see them at the grocery store together? Didn't I see them? And I suspect that Manhattan isn't so big. You're not the big Manhattan. I suspect Manhattan isn't so big that you don't bump into people off hours and you see, oh, okay, they work together. Oh, wow, they're a couple. All right, yeah. Oh, well, maybe they're just friends. Nope, they're a couple. Okay, got it. All right, that's why I know that. Well, then I can be confused maybe as a supervisor, understandably. And a few months later, person B comes to me and says, yeah, I've never had to do this before, but the other person they're harassing me. I'm coming to work and they're saying things that's unwarranted. You have to be careful of falling into that trap of, I thought aren't you two together? Because if the answer is, well, we were together, but then I said, I don't want to be with you anymore, I'm moving on, what the 10th Circuit is acknowledged, what circuit after circuit is acknowledged is, grown-ups get to be engaged in personal relationships, right, off hours. They are engaged in a romantic relationship. That's their business as a general matter, okay? They also have the right to say, I don't want to be in this anymore. And people have a right to say, so I dated this person for 3 months. I've worked here for 3 years. I'd like to work here for 30 years. Does that mean that for the next 27 years, I have to just put up with this person getting close to me, getting in my space, right, making sexual advances? They're unwarranted. I've moved on. They're unwelcome. I've moved on. We have to be cautious with that. And that really, to me, is a big misnomer that gets really confusing, where people, I thought we were together. No, people have the right to say we were in a relationship, we were involved, and we're not anymore. So please be cautious of that too, because we're talking about sort of some of the red flags, some of the frequent problems, misnomers that we see. One of them is certainly this idea that, well, they're together, so that means that it can't be that unwelcome. It can't be sexual harassment. No, if people are broken up, if they've moved on, and somebody isn't dealing with it very well, and somebody is bringing that to work, what they're doing is two different things. One, you saw them at the movie theater, holding hands or in a relationship. Got it. They're in public. You notice that as a supervisor. Got it. Very separate thing is we're at work. I don't want this person doing this. We're not together. I want it to stop. those are two separate analyses, and as tricky as it can be, because people talk and people get into things, and information gets out there. There's not a whole lot of secrets inside of an organization sometimes, and that's understandable. But you want to be very cautious and tread lightly here, because that is a real misnomer. The idea that, well, they were together before, so somehow this isn't as bad. As much as this seems sort of like a fiction, you have to force yourself as a supervisor. You have to force yourself as the higher ups, as the department heads, as the individuals that are investigating a complaint of sexual harassment. Their past involvement is completely irrelevant. It's as if they were never together. And sometimes I've talked to people about that, and they go, yeah, but that doesn't really make sense. I mean, in the real world, I get it. I'm calling it a fiction because, yes, they were involved in a relationship, and that can be something that can give that department head or that supervisor sort of a mixed impression. I understand that. That's why I think it's important to talk about it, is because I can understand that. I think it can be sort of, well, what if they get back together? Got all that. We have to subscribe to this fiction, though. In some ways, it's a fiction. Maybe that's not the best word, but just imagine that you didn't see him at the movie theater. Imagine that you didn't know. Here's what you got: a person in front of you saying, "I just want to come to work," and this person keeps doing A, B, and C. And I think something should be done. That is completely separate from what you saw on Facebook, what you saw on relationship status there, what you saw at the movie theater, what you saw at the grocery store, what you saw at the restaurant. It's completely separate. And that can sometimes be easier said than done, but in all honesty, I'm in the business of saying things that are easier said than done. I find myself, next week I'll be in Michigan for a day of training, and then I'll be in South Carolina for a couple of days of training, and I promise you that I'm going to say on multiple occasions, I know, get that list ready, easy for him to say, and then fly out of town. Fair enough. I show up in a suit and I say, this is the best practices, this is what we think works, this is what the case law indicates is effective, this is what common sense, this is what 7 years of seeing the aftermath of these things gone sideways shows us, and then I leave town or I end the webinar, and easy for me to say, get all that. Just because it's easy for somebody to say doesn't mean that it's not factually correct. And what I'm really trying to express to you in this webinar is there's these things that we see as patterns. And there's things that I would submit to you that is someone that really has a unique opportunity. I get to travel around the country. I'm in a different state every week. I get to see those patterns and things that sometimes seem like, well, this is a Manhattan, Kansas problem, right? This is a Kansas City, Kansas problem. This is a Raleigh, North Carolina problem. There's so many of them that aren't. There's so many of them, it's just the accents change, the names, the faces change, but the fundamental problems, the fundamental pitfalls are strikingly similar. And so as much as this and so many other things that I've said during the webinar may strike you as easier said than done, and I understand that, particularly for the supervisor. I hope when you had an idea when you decided to become a supervisor, when you took on that additional responsibility within the city. But maybe it wasn't. What I think should be expressed, and I think that sometimes good municipalities and counties, good leaders, sometimes fail to do as much as they could. When it comes to letting people know you become a supervisor, a lot of things change. You are now in the world of personnel management. And there's a lot of things that are easier said than done, but they got to get done. It is easier said than done that you've got to take these things seriously when you have some role in the investigation, that you have to keep your personal matters, your personal views of their job, work performance, what you bet, what you think happened out of it. Those things are easier said than done, but it doesn't mean that they aren't vitally important to what we're talking about. Now, if you do have any questions, I'm not really sure of the best way to funnel them, but I certainly want to defer to the leaders there in the city. If they'd like to funnel questions through them, I'm sure that they will let you know, but I wanted to make sure that we have this at your fingertips. Matt at dolanconsultinggroup.com, Matt at dolanconsultinggroup.com. That's the best way to get a hold of me. So just want to get that out there. It's on our website, but I just thought I'd put it in front of you. So depending on our follow-up here with your HR and legal minds that are heading up those departments in Kansas, in the Manhattan, Kansas municipality, depending on how they want to handle things, I just want to make sure everybody sees this is my email address. It might take me a couple days. If you'll bear with me, I'm traveling a lot, but email is the best way to get a hold of me for follow-up questions, things that you would like clarified, things of that nature. That is the email address for me. So with that, I hope this is helpful to you. I hope that you continue to utilize, and this disclaimer is really about this, you've got legal resources. You've got HR there, especially for the supervisors, for the department heads. Please take advantage of their knowledge as a resource, and please know that in so many cases, you wish you could go back in time. and ask them, okay, this is what I got, as opposed to this is what I did, right? Because then there's damage control, only so much you can do. So with that, Justin, I think that'll conclude our webinar. Folks, thank you very much. Appreciate the opportunity, and I hope that this information has been helpful on this very important and timely topic of sexual harassment liability. Thank you.